Hold up, did we just catch a violation in the wild? The defendant's ankle monitor, aka the SCRAM, got tampered with, and the excuses are already rolling in. Boots, socks, neuropathy cream. This is either the most creative alibi or the sloppiest cover-up. But here's the kicker. SCRAM devices detect alcohol through sweat. If it's not reading skin contact for 10 hours, someone's playing games.
Okay, so I have talked to pretrial in regards to the violations as to tampering with the SCRAM.
You need a translator anyway, right?
I guess
Did
so.
Ramirez?
Yes. So pretrial doesn't know exactly what was tampered with. He does work in construction. He wears boots. He wears socks. He does.
Classic move. Block the censor, block the evidence. But here's the legal tea. Tampering with a SCRAM isn't just a oops, it's a deliberate violation that screams, I'm hiding something. And guess what? Courts hate that. Police car lights so, audience poll, medical necessity or calculated risk. Drop your bets in the comments.
Suffer from this condition called neuropathy, where he has to put like this cream on here. He says that SCRAM actually has been causing him a lot of pain on his legs, so sometimes he shifts it to put the lotion or moves it. But since it was in the morning, he said it was probably like when he was at work with the boots. But there was no like BAC, no alcohol, nothing. It was just tampering.
A lot of times the way they do it, they tamper with it so that alcohol can't be detected. They'll put something in between the leg and the monitor to...
Let's break this down, folks. That ankle monitor, called a SCRAM, detects alcohol through the skin. So when it's not detecting anything for 10 hours straight, that's a red flag bigger than a courtroom objection. And that excuse about neuropathy lotion, is it legit or just a clever workaround? What do you think? Comment below, did he tamper, or is it just a medical mishap?
Evade. This is Enrique Ramirez.
This was,
A lot of times they'll say the tamper was from midnight to like 6 in the morning so that we know that there was something in between the leg or they've done something for that length of time. I don't know.
See the first one,
And it says
began
alcohol was
at
detected.
on March 1st at 4:32 a.m., returned to baseline at 2:40 p.m. That tamper was 10 hours and 8 minutes.
Come up, Mr. Ramirez.
I don't see the second one. I see the one on the first only.
Tengo que te estás, que tienes alcohol en tu sistema y que estás fallando con la máquina también. No, sir. La máquina me dice otra cosa. I don't know what to tell you, with all respect.
The judge isn't buying the cream excuse. And now, alcohol's been detected post-tampering. That's not just a violation, it's a confession without words. Bottle with popping cork high voltage, but wait. Why no alcohol on the second tamper? Did he learn his lesson, or just get better at cheating the system?
oh, I mean, pretrial doesn't have knowledge as far as like what was tampering. I mean,
They can't. It's impossible.
I know that, Judge.
It is, all we know is that the device was not detecting his skin for a certain period of time, and at the same time, alcohol is detected.
¿Dónde estás el día primero y el día 8?
So let's do this. I need to get a translate here so I can properly translate and let him know what I'm going to. Oh, Blasa.
Yes.
Can I borrow you for a second, please?
Baptism?
I just need you to help me translate.
Oh, okay.
Mr. Ramirez. Your
Boom, there it is. Alcohol detected after a known tamper event. That's not just a violation, it's a potential violation with consequences. And with 207 days on the docket already? This case is aged like courtroom cheese. The judge is clearly losing patience. But here's the twist, no alcohol on the second tamper event. Suspicious or coincidence?
instructed not to tamper or remove the device. We have two tamper events here where on March 1st at 6:33 a.m., and the second one on March 10th of 2025 at 11.
Game over. The judge just dropped the hammer, drug test, custody threat, and a side of "I told you so." This is why you don't mess with court orders, folks. But here's the twist. The defendant's claiming the cream messed with the readings. Thinking face, could this be a legit medical loophole? Or is he scrambling? Pun intended.
a.m. Alcohol was detected on the first event. Alcohol was not detected during the second tamper event. That's what I have. We need to do something with this case. It's 207 days old and he's now tampering with the device. So
I know, Judge. I mean, we're ready for plea today, but
you're tampering with the device and you're consuming alcohol. Told you not to. Let's do this. I'll send it for a drug and alcohol test right now and he'll.
yeah, Judge, yeah, because he has no status. If he goes in custody, he will get a nice hold.
I have admonished you ad nauseum not to violate conditions, because if you go to jail, there will be serious consequences. And we now have tamper events and a positive alcohol rating. I am now going to send you for an alcohol and drug test right now. I want to know what, if anything, that you will test positive and you're to come right back. And we'll see.
Yeah, because he does say, he does use the creams on his arms and hands, so it doesn't have a BAC level or anything in regards to the SCRAM, so.
Advised of.
I understand, Judge, I understand.
All I know is that alcohol was detected and he's tampering with the device.
Okay, all right, Judge. All right, well, so I'll step out and then, okay, thank you.
What's up, man?
I'm here for Ricardo. He just said he just wanted to
Ricardo.
approach for an admonishment. So
Kim is here.
Oh, Dave's there. Okay. Hey, Dave. Sorry, man. I've been in different courts.
okay. I mean, if it's just for an admonishment, then I can just sit here. Like if it was something contested, it'd be different. But it's just literally, it was the judge. It was the one we approached on Monday for the remand, and it's just I guess telling him about.
Do you want me to bring him out?
Yeah, let's bring him out. Can we bring out Mr. Joshua Sweat? Because I did want to talk about the reason why they're asking for an extension. And I talked to the client and I need to bring this up. So.
Not happy?
Well, it's part of it. I think you're saying that he's medically unfit to be transferred. I think that's the reason that.
Right. So, I mean, in plain speak, he's detoxing, and medical needs to figure out when they're finished with that before they can even, Louisiana can even initiate the transfer. That's the issue, is they can't even tell when they're coming because he's not cleared yet for transport, ironically. So, yeah.
So that's something that I want to address with client being here. Yeah, and sorry I waited till the end on this, Judge, but I've been running around. It's one of those days.
Hey, we're all feeling it. Don't worry about it. You're doing great. I'm tired too. And I still gotta go fix a flat tire, man. I had a flat tire. Come on.
Oh no! Hey, Judge, you got AAA? You don't have AAA?
No, because through your insurance, you have roadside assistance. Yeah. I'm not done. I forgot to call him though. Hey.
How you doing, sir?
How are you, Mr. Sweat?
Pretty good. How about yourself?
Well, let's talk. You know, I think that you, if I remember correctly, you have a parole violation out of
Louisiana, Judge.
No, Michigan, sir.
Or Michigan. Sorry, Michigan. I'm sorry. I conflated two cases.
That's right. He was a Michigander. That's what we were saying. That's right. You know, a lot of times in life, you really have to read the fine print. You got to read what you're signing. A lot of people just sign just because they want to be done with it. Yay, I'm getting on probation. Yay, I'm getting on parole. Let me just sign what I'm going to do. You know, one of the things that you sign in the jurisdiction where you signed, where you refused, or I'm sorry, you waived extradition by signing the document that you agreed to be on. So whether you agreed to get on parole, whether you agreed to be on probation, you refused extradition by signing the document in and of itself. And it says there, I will, you know, waive extradition if I ever become a fugitive from justice. You are now a fugitive from justice, meaning that you are wanted out of the other state.
Yes, sir.
So you can't sit here and say, you know what, I want to try to get a bond so I can just go turn myself in. You have already you have what's called a pre-signed waiver. You have already signed.
Mic drop moment. The judge just schooled us on waiver fine print. Signing parole docs? You might have accidentally signed away your rights. Memo collision. This is why legal literacy matters. People always read the details or end up like Mr. Sweat, stuck in detox limbo.
Yes, that's why I was trying to get back.
We are going to get you back.
Yes, sir.
The problem is that sometimes, we give them up to 30 days for them to come get you from Michigan.
I was under the impression it was 14.
In the typical instance where I don't give someone a bond, but for pre-signed waiver cases, it's 30 days.
Judge, and if I may, that's my argument. When we did all this, we always talk about the practice of 14 days. And so when we originally talked, we reset it out 14 days, and we were all basing it on the 14 days. Now, the extension that they're seeking is, my understanding, because he is detoxing. And at that point, my question is, I talked to him when we talked about the 14 days. We understood each other. He understood me. He seemed fine. I talked to him again today. He seems fine.
And he may be fine now, but when he probably first got here and when everybody was notified, it may have been a different story. He may have been like, just
No, I talked to him when we talked about the waiver, Judge.
Yeah, I'd been off my detox medication by the time I signed my waiver. I was no longer on even any detox medication.
And so my argument, Judge, I get it. And my argument is, hey, he's ready to go. We don't need extra time. Why are we holding him here extra days? Yeah, he signed the pre-signed waiver, but we talked about 14. If they're supposed to be here in 14, that's the practice. He's good to go.
That's not the practice for pre-signed waivers. It's not right. The 14 days, and understand the 14 days, hold on.
Yes, sir.
The 14 days
Yes, sir.
is us being nice, because statutorily, it's 30 days. Even in the instance where if it were a 14-day thing where I'm going to give someone a bond or this or that, statutorily, it's 30 days. We do 14 days because we have so many damn people in jail that we try to get them out as quick as possible. So as a courtesy to you, it's for everybody else, not for pre-signed waiver cases. We, as a courtesy, do 14 days. But in reality, we have 30, or they have 30 to come get you. And then Harris County releases you at that time.
May I say one thing?
Sure.
It would have been 8 days ago, last Tuesday. They told me ATW. I went downstairs. They said Michigan is here to get you. I waited 4 hours and in the holding cell. Then they said, actually, they're not coming. I had to go all the way back to the booking process again. They took my money from my account, put it in a check. I cannot go to commissary, can't go to commissary. And the waiver that I did sign, I did read the fine print, and it said they have 14 days, and if they do not, 10 business days, 14 calendar days, and if not, then they can seek an extension if necessary. My argument, I understand everything you said, and I'm not questioning I know the law more than you, but I did read the fine print.
So hold on, let's find out. Mr. Kim,
Yes, Judge.
what's the good word? Tell me
So
about-
they're supposed to be giving an update this afternoon. Hold on, I don't want to misspeak. Yes, I got an email about an hour ago, I want to say, that they should give the final update yesterday, but it's one where obviously they have to medically clear him, liability alone, in terms of, I'm not going to just, trust that he's good to go until a medical professional tells me that he's good to go for transport, because it's a liability on both, obviously, the sheriff's office side and Michigan side for the transport. We have.
You want to roll it till tomorrow to see what they say?
Well, that's fine, but it's just for an update, just because once the email comes in saying that he's clear, I would obviously relay that over to Ricardo. So, I mean, we can roll over, that's fine, but just rolling it over isn't going to rush their decision because they already have it on the forefront because we've been emailing about it.